Hello, good night. This is U.S. Immigration Attorney Sharifa Tharb. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so I can answer your questions. It's so good to see you tonight. Put your questions in the comments. All right. So I have some good news, some exciting news. What we have just now seen that the priority date is current for a certain category. Usually there's a wait list in order to apply for adjustment of status. And keep in mind that this now current priority date also means that VAWA applicants who are spouses of permanent residents, parents, spouses of permanent residents, or sons or daughters of permanent residents can now apply for adjustment of status while being in the United States. And what I'm talking about, the category I'm talking about right now, is the priority date for spouses, sons, and daughters of permanent residents. So usually, everybody hears about the benefit of being the spouse of a US citizen, or the parent of an adult US citizen, or the son or daughter under 21 of a US citizen. Oftentimes, some people may not know exactly why, but a lot of times people do know that being the spouse of a permanent resident is not the same as being the spouse of a US citizen. But here's the deal now. Here's what's happening is because the priority date is current for spouses of permanent residents, it now means that permanent residents, oh, the Jamaican accent is coming out. That's good. That's good. I think I have a strong Jamaican accent, so it's good that you noticed that. But here's the deal now. Spouses of permanent residents, children of permanent residents can now apply in a similar way as they would if they were the spouse of a US citizen. So what this means, the priority date is current, it means there's no wait list right now. You can apply for adjustment of status while being in the United States. But there are some key rules that you need to keep in mind that I'm going to lay out here. And what I say though is go ahead, get on it. Schedule time to talk to me so that we can come up with a plan and get started on your process as long as you qualify, right? If you're any immigration issue, but in particular to this case, if you're the spouse of a permanent resident, you're the parent, the son or daughter of a permanent resident, and you're under 21, or you have a pending case, you have a pending petition, you are waiting for it to become current, now is your time to go ahead and apply, right? But get in touch with us so we can talk, because I know this can be complicated. So this is why I'm trying to simplify it by just telling you this. There's no wait list right now to apply, right? And in a time where we're seeing a lot of delays, we're seeing pauses in cases, this is excellent news. And it really is like a shining light right now with everything going on. So keep that in mind, guys. There is no priority date. What about filing for a parent? Filing for a parent, it would have to mean that you are a US citizen. So there will never be a wait list for parents of US citizens, right? But there is a wait list for spouses and sons or daughters who are under 21 of permanent residents. But there is no more wait list right now. That can change next month. That can change in 2 months. It's urgent at this point to make sure that you understand whether you qualify and to be able to get started, right? on your adjustment of status should you qualify. I can't stress how great of an opportunity this is. Now, where else is there no wait list? For example, if you're being mistreated by your permanent resident spouse, you're being mistreated as a son or daughter, you're being mistreated as the son or daughter of a permanent resident. It also means that you can apply for adjustment of status, your work permit, your travel document, and your green card all in one go without a wait list. So I cannot stress how important of an update this is and how it can open up the door for many people who previously are stuck, either not understanding that they do have the ability to apply because there's a wait list. There's no wait list right now, but that can change. So get into the best thing you can do is just talk about your category with us, talk about where you are, how you qualify, and get started. Wish they could make the priority date for T visa current too. Oh boy, I tell you. And even guys, even with priority dates in place, it means what with a priority date in place, it means you get to apply. Without a priority date being current, you have to wait to apply, right? So the T visa is much better in that you qualify, you can apply. With this case, what it's saying is, oh, there's no more wait list. There's no more priority wait list. So you can now apply. It's basically giving you permission to apply. So it can be frustrating because you can't even make a move to apply, right? When it comes to family-based or VAWA. So let's get on it, guys. Let's get on it and move forward, because you know what my principle is already. You come up with a plan, act on faith, and you move forward, take action. And this is one of those ways to take action. All right, so I'm going to answer some questions. Let's see. So somebody says, what's the update? The update is if you're the spouse of a permanent resident, you're the son or daughter of a permanent resident, under 21 and unmarried, there is no wait list right now to apply for your green card while being in the US. Now, there are certain rules that you have to keep in mind. One is, as the spouse, when your permanent resident is petitioning for you, you must still be able to show that you're here in the US on current status. So if you're here on your visa on current status, right, you can apply through your spouse, your permanent resident spouse right now, as long as you're on current status. So this is one situation. You don't want to overstay. You want to apply before your time expires. Now, the other thing is, so you can't overstay. And then the other rule is the priority date has to be current, which it is current. So please make sure that if you're the spouse of a permanent resident, you are the son or daughter under 21 of a permanent resident, that you get in touch with us ASAP to get moving on this. Because this is a kind of change that it can change in the next month, right? But for April, it's current right now. Can out of status au pair J1 get work visa or a green card? It's possible, but it depends on your circumstances. So this is where we need to talk to you about what's going on so that we can come up with a plan for you. But it may be possible. How about the I-140? So it depends on what category. So I-140 comes in EB1, EB2, EB3 categories, and they all have different priority dates. So this is the F2A category. F2A, spouses of permanent residents and children under 21 and unmarried of permanent residents don't have a wait list right now. If you're in the US, you can now apply for adjustment of status to get your green card right now. The other thing to keep in mind, though, is if you're here in the US and your VAWA, right, your spouse or your parent is mistreating you, your permanent resident or your permanent resident parent or spouse is mistreating you, you can apply even if you've overstayed, right? Even if you've been here 10 years, the priority date is now current, you can apply. So this is where I say, don't count yourself out. You need to make sure you're talking to us or talking to an immigration attorney to understand how does this apply to you specifically, and jump on it quickly, right? Because I don't want people, it's complicated in a way, and I'm trying to simplify it as much as possible, but I don't want you to count yourself out, right? I want you to be able to get access to legal advice to help you to move forward. Is it safe to travel outside of the USA with advanced parole? It depends. It depends. No, I still do encourage my clients to get a travel document because things happen. They have relatives, parents, children who live in other countries. And if an emergency happens, at least they have that to be able to travel on an emergency basis. However, it is a lot riskier to travel outside of the United States, and you need to make sure you consult your attorney before traveling. Good evening, please. I'm not sure. So please, a friend request. How many years is the VAWA application approval? So I'm no longer gonna get into case processing times. I think I've repeated myself many times, and it's even though I'm just the messenger, it's really being held against me. So I'm no longer going to be talking about case processing times. However, it's not that I'm not going to give you the information to empower yourself, but you need to make sure you're holding the right people responsible for processing times. And I say repeatedly, I don't control processing times. So go to uscis.gov and you can learn about case processing times there and learn about the USCIS's processing times. What I am talking about, though, are ways to be able to get your papers here, especially in difficult situations you're in. I'm going to be focusing on those solutions that we work with. Case processing times, you can check your own case status if you have a case processing, or go to uscis.gov, or once we are in an appointment, then I can talk to you about what to expect in the process, but I'm not going to be addressing those questions here. If undocumented, can one pass employment background check? It may be possible, and it just depends on what kind of background check. So you have different kinds, and so one of them is the I-9 verification process, where if you are undocumented, you have a social, but it's not valid for work, the employer usually gets notification of that during the I-9 process. So, but say they're just looking at criminal background check, then, in many cases, they will not check your immigration status. My 20-year-old son has an interview this month, and I petitioned for him. Will he be able to come before 21? So usually if you are a US citizen, I'm not sure if you are, but if you're a US citizen, and the day you apply and it's accepted by the USCIS, it means that it's your child's age is frozen there. So that's the good news, is that once you file the petition, it's approved. Now he's gone on to the interview. It's likely that he will be okay. Now, if you're not a US citizen, then there is a calculation that they would do to determine whether he can still move forward and get the green card. In this case, I would say it's very likely that he will still meet the age requirement to be able to get the green card. However, I'm not your attorney. I can't give you personalized legal advice. Based on experience, it looks like that's what could happen. So what I would encourage you to do is focus, make sure your son, when they're going to the interview, they have everything they need to succeed in that interview. When we prepare our clients for interviews, even at the embassies in their country, we send an entire packet for them. We send everything, all documents in order that the officer usually asks for them. And we prep our clients very thoroughly to be able to get through that interview. I would suggest you make sure you do the same thing. Make sure any documents that you even think they may want, you make sure you put it there. Here's what I'll do. I'll give you some quick tips here. So the sticking points usually with interviews, especially at the embassy, is the affidavit of support. You want to make sure that the affidavit of support, you want to provide an updated tax return, updated tax statement, updated income information, in case the officer asks for that. So you want to make sure your affidavit of support, everything is signed, everything is signed and sealed and accurate. So, because that's usually one of the sticking points. The other are civil documents. So usually they will want, and the embassy will be very specific about marriage certificates, divorce decrees, birth certificates. Make sure you have your originals along with a copy of the originals of your civil documents, because in many instances, the officer wants to see the original. They at least want to feel and look at the original. And so do not assume a copy is going to do. Make sure you have your original documents with you. Of course, make sure you have your interview letter, as well as your visa confirmation application barcode. Usually they'll use that to let you into the interview. So of course, make sure you have those documents. So I would just say, while I don't know your case, make sure that those are usually the sticking points. So make sure you're focusing on those. There may be other sticking points, just depending on your circumstances, which I don't know. But I know those are very common issues that you need to focus on. Thanks so much for the love. I appreciate it. When will the immigrant visa be available for Caribbean people? So now there's no across the board ban on all countries. Some countries have an immigrant visa pause right now. When will it be lifted? I know it's not lifted now, but and I don't know when. Any news on ban for I-130 for Jamaica? No. What I do want everybody to understand is it's not banned, right? Yes, there's a pause, but I don't want you to use the word banned, because your banned means don't even apply. You're not eligible. And that is going to hurt a lot of people if they think that they're banned, right? So there's an indefinite pause, which is not much better than a ban, but I need you to see the difference, because I don't want people. So for example, I'll give you an example where that can be harmful, right? Where an assumption that you don't qualify to apply for an I-130 can be harmful. For example, a parent, a US citizen parent, wants to petition for their son in Jamaica, and their son is 20 years old. The indefinite pause on the I-130 petition, the immigrant visa, has been announced. Now, because of that, and keep in mind, it's not even based on the I-130. So we don't even want to say that. It's the I-130 is not banned. The immigrant visa is banned, right? So what happens here is, if somebody has a misconception that the I-130 is banned, that parent of that 20-year-old will decide, oh, I'm ineligible to apply for the I-130. So I'm just not going to apply for my child who's 20 years old, right? But the truth is, they do qualify to file the I-130 petition. It's just that there's a pause on it. So they'll accept it, they just won't issue an immigrant visa, which an immigrant visa, it doesn't come until after the I-130 is approved, not until a year and a half to 2 years or later, right? So in that case, that parent just made a decision that was detrimental to their child and their child's future in the US because they had the misconception that there's a ban that they can't apply. The issue is, here's where the issue comes up. Now, say a year later, the pause is lifted and their child turns 21. Because they didn't apply for their child when their child was 20, they no longer can apply for their child on that faster case processing time. So this is where it's very important to not not giving into the village lawyers that say all of these blanket statements that are not true, the overbroad statements that are not true. Make sure you're listening, you're talking to an attorney about your particular case, and make sure that you are listening to reputable sources and really empowering yourself with knowledge, the right knowledge, because we don't want people to think they can't apply for things that they may very well qualify for. EB2 NIW can apply if I have a pending VAWA at the same time. It may be possible, but I would have additional questions. The main issue with the national interest waiver when it comes to being here in the US is, once again, that priority date. Will you have current status at the time that you're applying for the national interest waiver? And then when you're here applying for the national interest waiver, you would also have to know that you cannot apply for adjustment of status until the priority date is current. And the thing about it is, if you are here in the US, your time is close to expiring, as in your visa status is close to expire, or it has expired, it basically means that adjustment of status is unlikely to be your option. So, but we'd have to talk, because you may fall within exceptions here, but it gets a little complicated. I have last month removal order, so now I did motion to reopen. Know what will happen. So if you do a motion to reopen, it's gonna go through the BIA. I think that's the BIA that you've applied to, and then the BIA is gonna make a decision. Now the BIA has no, or they will be changing the way that they look at appeals. So keep that in mind as well, that if you don't succeed at the BIA, you may have to look at the federal court as well. And that's a good question, Kudet. I'm glad you brought up the question, because it allows me to explain about the the pause on the immigrant visa and the fact that it's so important to still move ahead with your process, but with legal advice. Hello, having an approved I-130 and then an adjustment of status is filed. How long does it take to get the work permit, travel document, and green card? Go to uscis.gov and you'll see it there. So I'm not gonna talk about case processing times because it's shifting so much, and it's shifting in a longer direction. So because I say today, it changes tomorrow. So please go to anybody want to know case processing times, go to uscis.gov and go to case processing times. All right. My VAWA pending since 2020. No RFE, only PF. Congress said pending background check. What does this mean? Congress? I'm not sure. Oh, so you went through a congressional liaison. So they're basically going through the background check. So what they're saying is this has been pending because they're looking at your background. I don't know if there's 2020 to be waiting for a VAWA since 2020 is for excessively long. However, sometimes the way that USCIS gets around excessive processing times is usually by stating that they're doing additional background checks. So I have seen this in cases where they are really digging into your background. Maybe there are certain questions that they have about your case that they may be looking at. So it may be that that's the case. So if my friend come to the US on an RC1, a visa type, can he get married and get a green card? Your friend should be consulting an attorney. There are certain visas that if you come to the United States and overstay those visas, for example, like the C1D visa, it will lead to a permanent bar. There are exceptions like VAWA and the T visa. However, getting married and doing it through marriage may not fix that situation. So your friend needs to make sure that they fully understand any kind of the effect of the type of visa they use to enter the country. Is fiance visa available to suspended countries like Nigeria? So keep in mind that in Nigeria, it's not a full ban. So there's a partial ban. And so that the fiance visa is not one of the visas that are limited. Good night. How long does it take for your biometrics? It differs from case to case. I searched on USCIS website looking for filing fee for I-751. I don't see it. How much is it? It's best to go. The USCIS is going to have it, so make sure you check there. They are going to have the accurate, most up to date information on the filing fees. Does the April visa bulletin have any positive effect on VAWA applicants? Great question. Absolutely. So those VAWA applicants who are spouses of permanent residents or sons or daughters of permanent residents can apply for adjustment of status right now. Adjustment of status, their work permit, their travel document, they can apply for that right now. So that is the positive effect. So for sure, VAWA applicants, there's no wait list to apply for adjustment of status. You can go for it if you qualify for VAWA. Oh, thank you for the compliment. I appreciate it. When should I start to file for them to come to the USA? Should they qualify? So I married my Dominican wife in DR, November 2025. She has a 10-year-old son from prior unmarried. No, I guess the first thing, talk to an attorney. You can always call us. We deal with cases like this, but there's no better time than right now. What if your spouse is a US citizen, have an SSN before? Can the person file for work permit? Yes. Yes, absolutely. So if your spouse is a U.S. citizen, it's basically part of the standard here at the firm to apply for the work permit for clients with their adjustment of status. How can I get help with an asylum? Get in touch with us. We do that. Get in touch with us, talk to us so we can jump on it. There is a deadline for asylum. And by the way, today we got 2 work permits from our asylum applicants or asylum clients. And we got another work permit approved for VAWA. So these are moving forward, guys. We are seeing results. So make sure you jump on it. There is still the ability to get the work permit through asylum. Now, what they are looking at is lengthening the time to before you can get a work permit with the asylum. So you need to make sure you treat it with urgency if you want to apply before they start to make those changes. Can green card holders file for kids in Jamaica even though it's on pause? I encourage you, yes, to move forward with that. If you are not applying, then you're possibly foregoing eligibility depending on how old your kids are. So absolutely. Hey, good. How can I apply to adjust my status when you overstay your visa? So it depends on no, it depends on what you qualify for. If you're married to a US citizen or you were even you're being mistreated by a US citizen spouse, that's one way. But we'd have to really understand how do you qualify exactly. There are ways, but we have to understand. I would say this. I'd want to talk to you to find out your circumstances to see what there is, because that's what we do. We hear your circumstances, whether you overstayed, whether you came in without papers. We hear your circumstances, and then we can look at the options that we work with. Can a person waiting for I-485 and apply for TPS? Yes, as long as you have a country, you are the citizen of a country that has been designated a TPS country and that you're still within the application window to apply for the TPS. My priority date is March 2022. I'm in the F1 category. How long you think I have to wait? So if your priority date is now, if you're F1, then I would have to look at the bulletin to tell you the time because that's not current. What I'm talking about now is the F2A category that has no wait list. I filed my VAWA 6 months ago and I received my VAWA receipt yesterday, but only the I-360. So if you filed the other applications, those should be coming soon, or they may be sending correspondence about those. But you just have to confirm if you filed like an adjustment of status, work permit, travel document, along with the I-360. You just want to make sure what I do is track all packages to ensure that I am confident it got there and it was signed off by the mailroom as being received. If that's the case, they now sent your receipt notice for the I-360. The others are probably going to follow. What if you don't have enough proof for VAWA, but you still filed it? If you're going to approach it that way, you're in trouble, right? Because there's nothing with immigration that you can file without enough proof. So if you're saying you don't have enough proof, then you're already setting yourself up for failure, right? Now, with VAWA, having a very detailed declaration can be a good evidence. You will need, there are different criteria you need to prove. So you need to show that you live together. You need to show that you had I don't know if this was marriage based. I'm assuming it's marriage based, but you need to show the relationship. You need to show you live together. You need to show that you have a bona fide or had a bona fide marriage. So that those are some of the evidence, and you have to talk about the mistreatment, which is the declaration is usually accepted as evidence as long as it's credible. But I don't know what you mean here about not having enough proof, because I don't file applications if I don't have enough proof, right? It just doesn't, it would be setting up my clients for failure. So you would be in trouble then. What is the process of reporting a marriage scam? So I don't have that information. If you do, so USCIS, they have hotlines and information on how to report like marriage scams or anything like that. I've an upcoming flight, but my middle name is spelled incorrectly. Will it be an issue? It may be, depending on where's your name incorrect. Is it incorrect on your passport? If that's the case, it may be an issue. I searched on USCIS website looking for filing fee for I-751. I don't see it. So if you don't see it, that would be a real problem, but it is there. If my friend come to the US, okay, so I answered that. Good night, just joining. What is the difference? What's the difference between chart A and B, the visa bulletin? So one indicates when it's time to apply. So when is it time? The other indicates when they have completed the processing times for those who are in process. So chart, the one with the current priority date is the one that you need to be looking at in order to determine when to apply. Can I travel to the USA on an H-2B visa while waiting on my I-130 to be approved? If you have a valid current H-2B visa, yes. So they should, that's a part of the process. They should be aware of your I-130 petition as well. That's really something that you wouldn't be able to hide. So if you have a valid current H-2B visa, then you should be fine, because that's information that should have been provided to them as well. Hello, I was granted asylum 2024, but never received I-94 and work permit. Can I apply for a green card? So if you were granted asylum and you have proof of the granting of the asylum, then you can move forward after 1 year to apply for your green card. So yeah, that would definitely be something we would definitely work to be able to get you your green card on time. If someone got a detainer on them, what does that mean? So usually what a detainer means is, so when somebody is locked up by the police or the sheriff's office, if they see that the person is an immigrant, they will contact immigration, and an immigration will put a detainer on them to basically say, hold them, we want them, so please hold them, don't release them for the next 48 to 72 hours, and then we'll come and pick them up to take them into ICE detention. How do you know if you are on the window to apply for TPS? So if you go to uscis.gov, and then you just look up the TPS countries, so you research that on uscis.gov, they will, if you, I don't know what country you're from, but you'd look at the designated country, and then you'd look at the timelines that you're given to apply. Can my spouse adjust his status without leaving the US? He entered illegally. Only in certain circumstances, not through marriage to a US citizen unless your spouse gets parole. So it would not be through a marriage-based process. There are other ways that we have seen our clients be able to adjust status even with an entry like that. So for example, through VAWA, through the T visa, through U visa, those are some of the ways. But unfortunately, in this case, marriage-based case is not going to work. Once there is an under illegal entry here. All right. Do you work on I-601 waivers? What are the next steps to take after I-601 is denied? So there may be two approaches. It's to appeal, if anything, or to be able to refile an I-601 if it was, so for example, some I-601s maybe it wasn't done correctly, or there wasn't enough evidence, but now you have evidence or circumstances have changed, then you would refile an I-601. So get in touch with us and we can talk it through. I work with Uber, lived in New York, but my asylum case is in Philly and I pay taxes in Philly. So I'm not sure where the other question is. I'm on Instagram now. I'm a teacher and receptionist. How can I take my US visa? You'd have to apply to get a US visa. Hi there. Can my 18-year-old son, who is a US citizen, file for his mother when he is 22? When he's 21, he would be able to file. So as soon as he turns 21, he'd be able to file for you. Can it be possible for me with a first school level certificate, or is there a visa for that? So let me just see okay. Hi everyone, my name is Danielle. Is it possible for someone who only has a first school level certificate and works in the United States? Is there a visa that allows this? I'm a 22-year-old Cameroon. Yes, there are work visas and work green cards available, even if you have, no matter your education. So it just all depends on, for example, the employer, the position, the type of visa that you're looking at. Hello, having an approved I-130 and then an adjustment of status is filed. How long does it take to get the work permit, travel document, and green card? Go to uscis.gov and you'll be able to see case processing times there for those applications. Hi there, good night. I have last month removal order, so I answered that. Okay, so now I'm on, wow, we have a lot on YouTube and Facebook, so let me go ahead and answer these. Hey, I filed for VAWA on the CO9 prima facie and it's been 19 months for work permit yet. Should I be worried? Go to uscis.gov, look at their case processing times, and that will tell you whether you are within the average case processing times or you are outside of the average case processing times. So that's gonna be where you need to start. Does applying for VAWA affect the LPR residency, like his green card being revoked? Does applying for VAWA affect the LPR residency, like his green card being revoked? So the VAWA leads to the green card. So it wouldn't know once it's a green card is approved. Under VAWA, there's no risk there. Well, thank you so much for that, Ahmed. I appreciate that. So, how long we take to file cases, we work as quickly as possible. So, the shortest possible time it can take us to apply for your case, we're going to do it. However, I wouldn't be able to tell you how long just because the case types that we work with, like VAWA and T visa, are very complicated in some cases, especially now where we want to make sure we're doing due diligence to submit a solid petition that has an increased likelihood of success. But we do work. If it's going to take 2 weeks to get it done, we can do it in 2 weeks. But if it's going to take a month because we have to wait for an extra background check or we have to do our due diligence in collecting additional evidence, well, we need to take that month. And then again, it all depends. If there's a deadline coming up, then we look at certain strategies to apply early and then to supplement as well. Although supplementing is always a last resort type of approach. So, but this is what you should do, Ahmed. Get in touch with us, talk to me in an appointment, and then we'll talk about your circumstances, and then I can give you an idea of how quickly we can work to file your case, because then I can know what your case looks like. Is it normal or something else happened, like my lawyer didn't respond to the USCIS RFE or something? So let me see. My VAWA was submitted on 11/2022. Then I submitted expedite request on 3/2023 for VAWA. And the request was approved. I was issued EAD and I-131, but my VAWA I-360 is still pending. So what you can do is go to uscis.gov, look at the case processing times, and then you'll be able to see, is your case within the timeline that they have? That means that it probably is not out of the ordinary. I did my biometrics for T visa EAD, but only had a photo taken. The lady said that I only need my photo taken. Is it normal to not have your fingerprints taken? This is my first time with USCIS. So yes, it's possible if they already have your fingerprint. So if you recently took off your biometrics before, they already have your fingerprints, it's possible that they only need your photo. Is there a new public charge rule? Yes. So the new public charge rule is extreme. It gives officers extreme discretion to determine whether to basically use the immigrant circumstances to determine, or basically to judge whether they think, based on their discretion, the immigrant is likely to depend on public assistance as part of their sustenance, as a majority of their support. The danger with this is that it's so broad. The new public charge rule is so broad that they can look at, maybe the officer can say, look at your education, look at your work history, look at your history of taking benefits like food stamps, and then determine that, okay, based on those, or maybe even your health, right? Because now they can even look at your health and say, oh, well, you have a chronic illness. And because you have this chronic illness, you're likely to become a public charge, and that officer can then has the discretion now to then deny your case based on justifying it by saying you may go on public medical care, so Medicaid, because you have diabetes, right? And they don't say how your background doesn't indicate that you would be able to afford the medicine. This is an example of the line of thinking that officers may adopt. You may have, a few officers that they may go that far with the level of discretion that they have under the new public charge rule. So this is where I say don't oversimplify this process anymore, because it is anything but simple. The type of analysis on the officer side is a lot more unpredictable because of broad rules like this. Thank you so much for the love. I appreciate it. All right. These are all great questions. I'm from one of the partial banned countries, but live in the USA with my USC husband. He filed I-140, which I think that's I-130 and I-485 in December, and EAD in February, biometrics done in February 2026. Should I expect EAD soon? So what I suggest you do is go to the USCIS.gov website and look at the case processing times for the I-765. And it's going to give you an idea of the maximum wait time for that EAD right now. I filed adjustment of status March 2024, still no call for interview yet. What is your advice? So, yeah, basically 2 years waiting. I would say that is unusual, not to have an interview within the past 2 years. You can always go ahead and submit an inquiry. But keep in mind, once again, looking at case processing times, if you're within the case processing times, then that inquiry is not going to go anywhere. You can also call and just check to make sure that everything, because the officers, at least the officer can look to see, is there anything missing? Are there any correspondences that they sent that you didn't get by chance? So maybe that would also give you a chance to catch anything that was missed. Can my son, before he turns 21, start filing for his mother in advance before he reaches 21 so the process speeds up faster? No, he has to be 21 before he can file for his parent, and 21 and a U.S. citizen. I filed adjustment of spouse. I answered that. Can you file I-751 before 90 days of expiration of the 2-year green card? Great question. In certain circumstances, if you are applying without your spouse, then yes, you can apply at any time before the 90 days. And that would mean you're submitting a waiver. Yep, so I just answered that. Where do I get the correct number to call, please? I'm not sure what number. Okay, so go to uscis.gov and you'll see the number there. If someone divorced the abused spouse after applying for VAWA and remarry from his ex-wife, the one he married before the abused spouse, is this considered a fraud? So keep in mind, okay, so there's a number of things going on here. When you're applying for VAWA, you should not be remarrying. If you can divorce, but if you remarry, your case is dead. They're gonna deny the case because remarrying means that you lose eligibility for VAWA. So that's one. So please make sure you don't, if whenever you are applying for anything, make sure you're checking before making any major moves like that. Now, what if you go back to the ex-wife and remarry the ex-wife? Is it considered fraud? There may be questions. It's if you know you married your ex-spouse, both marriages were valid and bona fide, you know that, then we know it's not fraud, right? But it doesn't stop them from asking questions. And at that point, you just have to be aware of the kinds of questions that could come up so that you can address them with the officer if the officer asks. All right, let's see. Can we have your contact information? Absolutely. So give our office a call. It's 561-405-4889. Let me see if I can put it in the comments. And you're going to see it under my name, immigration lawyer Sharifa, 405. Okay, so it's immigration attorney Sharifa. You'll see it under the comments there. Also, go to the link in the profile. You can get to know us at the firm, get to know the team. You can get to know the cases that we work on and the many successes that we've had. Go to the link in the profile and then go to the website. So Linktree and then the website. It's S as in Sam, T as in Tom, stlawoffice.com. You'll learn all about the firm and you can get in touch with us there as well. Can someone with a 2-year green card from one of the banned countries, are they safe to travel? Yes, they can travel. So it's 561-405-4889. Can someone with a 2-year, so you can know just being from a banned country will not mean that you can't travel outside of the US. If you're a green card holder, you can travel. Just make sure though that you don't face any individual risk. Do T visas require 2 biometrics? It's MACE. In some cases, sometimes we have seen that, but it's not common. I filed my VAWA September 22, 2025, received my receipt yesterday, March 17. Wow. And only the I-360. Yeah, so it may be that the other applications are lagging behind. When can one apply for citizenship after getting your green card? 3 years if you're married to a U.S. citizen if you're married to a U.S. citizen for 3 years and you have a green card for 3 years, then you can get the citizenship after 3 years. Otherwise it's 5 years generally. Are spouses' visas still on pause? So spouses' visas have never been on pause. So this is where I say, I'm glad you're asking the question because I also want to be able to address those misconceptions. What visas are on pause? There's no visas on pause. In some cases, some countries citizens of some countries are facing pauses, but there are no visas that are on pause. You qualify, make sure you're checking if you're qualified and make sure you check with an immigration attorney. Can you get a divorce while filing VAWA? Yes. My I-485 was approved, but not my kids who are 12 and 14 years. How long I have to wait? It just depends. Can there be a mobile biometrics done for T visa for mental disability? So usually, if there's, that's an accommodation. So it really depends on the situation. Where is it gonna be, and what the accommodation needs to be. Can you help someone if they filed for a waiver and got through? Yes, yes. Give us a call and let's get started by talking about it first to verify, we can move forward and get started. All right. Thanks so much, guys, for your time tonight. I really love the questions, and I'm going to work to come on again tomorrow. So, what I say is like, subscribe, follow, hit the notification bell. That's going to be able to help you see when I come on so that you can join me and ask questions. All right. So until then, have a good night and stay safe out there. And let's take action to move forward. All right. Let's not be paralyzed by fear or misinformation. Make sure you're informed. You can always reach out to us and schedule time to talk to me so we can figure out what your solution is and get started on it. All right. Have a good night. Bye bye.